Why would an attorney who lost a trial ever want to speak to the jury after the case is over? You want to know the answer? Come join me as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial lawyer practicing law in the state of New York. You might be thinking, wait a second, if a lawyer just lost a case, why would he ever want to speak to the jury afterwards? Wouldn't he want to leave as quickly as possible? You will find that the best trial lawyers in New York, regardless of the outcome, will want to speak to the jury. You want to know why? It's because we don't know what goes on during the course of jury deliberation. There's no television camera with audio picking up all the deliberations that are going on when they're trying to reach a verdict. So we don't know what's going on in the minds of the jury. And now an attorney who has lost a case can gain useful insight and information by talking to the jurors who are willing to stick around and talk to the attorneys, because they don't have to. The judge will tell them, listen, the lawyers would like to speak to you. For those who want to stick around, you're welcome to do so, but you're not obligated. Now, those jurors who do stick around, what we want to try and find out is, hey, Mrs. Jones, what were you thinking? How was it that you reached the conclusion that you did? Why did you give the injured victim this amount of money and not this amount? What was the issue in the case? Were there any jurors who disagreed on what it was that we showed as a defense? Did anybody pressure you into reaching a decision? Now that's an important one for a defense attorney who loses a case, because he wants to know, was there pressure exerted upon any of the jurors to come to a certain conclusion? And if there was, now he might do some further investigation and try and talk to all the jurors, and then try and petition the court to try and either have a new trial because there was undue influence exerted in the jury room, or there could be other reasons to do that. But at least it gives the attorney an insight and an understanding into what went on in their thinking. Now, he's not going to feel great about it, but still a smart attorney is going to turn around and say, okay, what was the issue in the case? Was it my presentation? Was it that you didn't like my client? Did you not believe this witness? Did you not believe our expert? By gaining this information, he now has a better sense of what actually went on, what the jury liked, and what they didn't like. So why do I share this terrific information with you? I share it with you just to give you an insight and an understanding into what goes on in a civil lawsuit involving an accident case, a medical malpractice case, or even a wrongful death case that goes to trial and reaches a verdict. And now the attorneys are debating whether or not to talk to the jury afterwards. You know, I recognize you've got questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you've got questions and you're contemplating bringing the lawsuit, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. You know, I do this every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, G-E-R-R-Y, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.